Good morning, everyone. I want to take some time today to speak directly to those of you who have been watching the headlines over the past several weeks, particularly since late January 2026, and feeling an understandable sense of concern, confusion, and in some cases real fear about what is happening with U.S. immigration processing. I've been practicing federal immigration law for over 25 years, and I can tell you that moments like these, when policy shifts rapidly and information moves faster than clarification, can feel overwhelming. But my goal today is not to add to that anxiety. My goal is to walk you through, slowly and carefully, what has actually happened, which countries and which visa categories are genuinely affected, and what this means for you if you are currently in the immigration system or planning to enter it. Let's start by acknowledging what everyone is calling the February 2026 freeze. That phrase has been used in headlines, on social media, in group chats, and in worried phone calls to attorneys like myself. But here's what I want you to understand from the outset. This is not a complete shutdown of the U.S. immigration system. What we are dealing with is a series of targeted pauses, expanded vetting procedures, and administrative holds that affect specific visa types, specific countries, and specific stages of processing. Some of these measures are temporary reviews. Some are indefinite but not permanent, and some apply only to consular processing abroad, not to individuals already present in the United States. So let's take a breath together and let's separate rumor from regulation. The most significant development, and the one generating the most concern, is the January 21st, 2026 State Department action. On that date, the Department of State announced a pause on immigrant visa issuance for nationals of 75 countries. Now let me be very precise about what that means. An immigrant visa is the visa category used when someone is approved for lawful permanent residence, commonly called a green card, and is processing that green card at a U.S. consulate or embassy abroad. This pause applies specifically to that consular stage of processing. It does not apply to non-immigrant visas, which include things like tourist visas, student visas, or temporary work visas, such as the H-1B. Those categories are subject to their own expanded vetting procedures, which I'll discuss in a moment, but they are not part of the 75-country immigrant visa pause. The stated reason for this pause is to allow the Department of State and the Department of Homeland Security to conduct what they are calling an expanded public charge and national security reassessment. In immigration terms, public charge refers to the determination of whether an individual is likely to become primarily dependent on the U.S. government for financial support. National security vetting, of course, involves background checks, biometric screening, and coordination with intelligence agencies. The pause is described as indefinite, and I know that word carries a lot of weight, but indefinite does not mean permanent. It means that there is no set end date at this time. It means the review process is ongoing. It does not mean that immigrant visa processing for these 75 countries has been eliminated or that approved petitions have been revoked. It means that consular officers in these countries have been instructed to hold visa issuance until further guidance is provided. Now, this is critical, and I want to say it clearly. If you are already inside the United States and you are applying for adjustment of status, which is the process of obtaining your green card while physically present in the U.S., you are not governed by the consular pause. Adjustment of status is a separate legal pathway. It is authorized by statute under the Immigration and Nationality Act. It is adjudicated by U.S. Citizenship and Immigration Services, not by a consulate, while USCIS has issued its own internal review memo, which I will explain shortly. Adjustment of status applicants are not automatically subject to the 75-country consular hold. This distinction matters enormously, and it is one that is often lost in the headlines. Let's now turn to the second major development, which is the January 1st, 2026 USCIS internal memo. This memo, which has been referred to as the Hold and Review Directive, places certain green card and immigration benefit applications from 39 designated high-risk countries into what USCIS calls extended administrative review. The countries on this list overlap in part with the 75-country State Department list, but they are not identical. The memo specifically affects adjustment of status applications, employment authorization document renewals, also known as work permits, and advance parole applications, which allows certain individuals to travel abroad and return while their green card cases are pending. What does extended administrative review mean in practice? It means that these cases are being held for additional background checks, additional interagency coordination, and additional scrutiny of the applicant's admissibility under current immigration law. It does not mean automatic denial. It does not mean the application has been rejected. It means the processing timeline has been extended, often significantly. I have seen cases that would normally take 6 to 8 months now, being projected into late 2026 or even early 2027. That is frustrating. That is difficult for families. But it is not the same as a door being permanently closed. The third element I want to address is the expansion of what federal agencies are now calling online presence review. This is a procedure that has existed in various forms for several years, but it has been significantly expanded in scope and application as of early 2026. Online presence review involves the examination of an applicant's social media accounts, publicly available digital footprints, consistency between online statements and immigration filings, and in some cases requests for passwords or account access as part of the visa interview process. This procedure is now being applied much more broadly to H-1B applicants, F-1 student visa applicants, and employment-based immigrant visa applicants across many countries, not just those on the 75-country pause list. What this means practically is that consular appointments are being rescheduled. Applicants who had interviews scheduled for February or early March are now being moved into April, May, or even June of 2026, because consular officers need additional time to complete these expanded checks. If you are affected by this, my advice is straightforward. Ensure that your social media presence, your public statements, and your immigration filings are consistent. Do not delete accounts or posts in a way that looks like you are trying to hide something. That can raise more red flags than the content itself. But do be mindful that what you post publicly can and likely will be reviewed as part of your application. Now let's talk about Temporary Protected Status, or TPS, because there have been several termination announcements that have understandably caused alarm. TPS is a form of temporary humanitarian protection granted to nationals of certain countries experiencing armed conflict, environmental disaster, or other extraordinary conditions. As of February 2026, we know that TPS designations for Ethiopia ended on February 13th, and the designation for Somalia is set to end on March 17th. There is also ongoing litigation regarding the TPS programs for Honduras, Nepal, and Nicaragua, with federal courts in different jurisdictions issuing preliminary rulings that may extend or block certain terminations. Here is what I need you to understand about TPS terminations. The end of a TPS designation does not mean that everyone from that country is immediately subject to deportation. It means that the temporary protection has ended, and individuals must either adjust to another legal status, depart the United States, or face the possibility of removal proceedings. Many TPS holders have been in the United States for years or even decades. Some have U.S. citizen children. Some may be eligible for other forms of relief, such as asylum, cancellation of removal, or family-based petitions. The termination of TPS is not the end of all legal options, but it does require proactive legal consultation and planning. Let me take a moment here to address something that I hear often in my practice and in the comments on videos like this one. People ask, why is this happening now? Why these countries? Why this vetting expansion? The honest answer is that immigration policy in the United States has always been shaped by a combination of national security concerns, political priorities, resource allocation, and international relations. Administrations change. Priorities shift. What was routine processing under one set of leadership can become extended review under another. That does not make it fair. It does not make it easy. But it does make it part of the reality of navigating the U.S. immigration system. What I can tell you, based on 25 years of experience, is that pauses like these have happened before. Review periods have happened before. And in most cases, processing eventually resumes, though often with new procedures, new requirements, or longer timelines. So what should you do if you are currently in the immigration process or planning to begin it? First, if you are outside the United States and your country is on the 75-country pause list, understand that immigrant visa interviews are not being scheduled at this time. That does not mean your approved petition has been cancelled. It means you are in a waiting period. Stay in contact with the National Visa Center if your case is at that stage. Monitor official State Department announcements. Do not rely solely on social media or unofficial sources for updates. Second, if you are inside the United States and applying for adjustment of status or work authorization renewal, prepare for longer processing times. Ensure that all of your documentation is complete, accurate, and consistent. If your work permit is expiring, file for renewal well in advance. USCIS has been issuing automatic extensions in some categories, but you must have filed before your current authorization expires to qualify. Third, if you are subject to online presence review or expanded vetting, take the time now to review your own digital footprint. Look at what is publicly visible. Ensure that it does not contradict anything in your immigration filings. If you have concerns, consult with an immigration attorney before your interview. I also want to offer a brief but important disclaimer here. Everything I am sharing with you today is educational information based on publicly available policy documents, federal memos, and my general experience in immigration law. It is not individualized legal advice. Every immigration case is different. Every person's circumstances are different. If you have specific questions about your own case, your own eligibility, or your own options, you should consult with a qualified immigration attorney who can review your particular situation. Let me close with this. I know that uncertainty is difficult. I know that waiting is difficult. I know that reading headlines about pauses and holds and terminations can feel like the ground is shifting beneath you. But I also want you to remember that immigration systems, by their nature, go through periods of tightening and periods of loosening. What we are seeing now is a tightening. It is a period of enhanced scrutiny and extended review, but it is not a permanent shutdown. The 75-country pause is indefinite, but it is reviewable. The USCIS hold and review memo is administrative, not statutory. Courts are actively hearing cases on TPS terminations. Things will continue to evolve, and in the meantime, the best thing you can do is stay informed, stay patient, and stay in lawful status wherever possible. If you found this breakdown helpful, I would appreciate it if you would share it with others who might be navigating these same concerns. And if you'd like to let me know in the comments which country you're from or which visa category you're dealing with, I do read those, and they help me understand what topics to cover in future videos. Thank you for watching, take care of yourselves, and remember, we will get through this together.